there a light on? The light is on? The light's not on?
Welcome, everyone. Can you hear me now? Great. That's a frequent refrain in Vermont. Can you hear me now, right? Thank you all for coming. We're delighted that you're joining us for the second in the Fast Forward series of events held by VTDigger. I'm Ann Galloway, the founder of VTDigger, which is now in its 10th year. Thank you all. The Fast Forward series is an extension of our mission-driven nonprofit journalism at VTDigger. As the state's only online nonprofit news organization, we seek to get past the sound bites and spin to explore issues that have an impact on Vermonters. Vermont is at a crossroads. As a state, we face a number of structural problems. Those issues are magnified as we address the impact of climate change, demographic shifts, globalization, and artificial intelligence. Ironically, the rise of social media has deepened our differences instead of bringing us together around practical solutions. Over the next few months, VTDigger is bringing together people with different points of view on public records, vaping, climate change, and the impact of racial discrimination on the state's population base. The purpose of the Fast Forward series is to give Vermonters an opportunity to sort through the complexities of these issues and see how local, state, and national leaders have used system change for public benefit. Tonight's Fast Forward discussion topic is, why isn't the state an open book? Many thanks to our sponsors, the ACLU of Vermont, Vermont Natural Resources Council, and the Vermont Bar Association. This is a geeky topic, so I'm glad you're all here. I see a lot of attorneys here in the crowd. But everyone in Vermont should care about public records.
Your mic just died.
Oh, I'm going to try this instead. How's this? Is this better?
No.
Yeah? No. Okay. Okay. Well, this is a geeky topic. Everyone in Vermont should care about access to records. Why? Because transparency is the only check on abuses of government power. Depending on who you ask.
It's like self-service.
It is kind of like cell service. Okay. Okay. Are we, no?
Right there.
Well, it's better that I'm the guinea pig than the parent. Depending on who you ask, the Public Records Act has at least 271 exemptions, and possibly as many as 500, according to the ACLU. By contrast, the federal FOIA has 9 exemptions. While certain exemptions are critical to protecting individual privacy,
It's
all right, is that better? There we go. Okay, finally, all right. While certain exemptions are critical to protecting individual privacy, others are used to protect corporations that are regulated by or do business with the state. 5 years ago, the Center for Public Integrity gave Vermont an F on public records access. Since then, the noose on access to records has arguably. Okay, how about if if I just, I'm just gonna shout. You guys can hear me, right?
No.
Okay.
And could you come in the middle?
I'm gonna come in the middle, yeah. Sorry about
Try
that.
to help place on the chair.
Okay. Since then, the noose on access to records is arguably tightened. State agencies in the city of Burlington have defaulted to a 13-day waiting period for records. Fees for redaction run in the thousands of dollars. In some cases, denials have taken weeks or have not been issued at all. The Vermont Attorney General's office has forced the relitigation of something called the bond index, which is built into the Public Records Act, and it requires state government to release lists of records that have been denied and exemptions for those records. Often we don't get that and have to fight for that in court. The Vermont Attorney General's office has also forced the relitigation of state precedent over personnel records, claiming that legitimate requests for information about state employee misconduct are personal. Let me give you one example of how tedious and expensive it can be to pursue records in the public interest. For 5 years, the state has blocked records pertaining to the role of Vermont officials in the EB-5 fraud scandal, which went on for a decade. Requests in 2015 simply were not responded to and then not fulfilled. At one point, the Vermont Attorney General's office told VTDigger we would need to pay $200,000 for a legal review and redaction of the records. Since then, the Vermont Attorney General's office has used a broad interpretation of the relevant litigation exemption to block 2/3 of the records collected by the state in the EB-5 fraud scandal. The 1 million pages that have been released are unsearchable PDFs that glom together things like emails, spreadsheets, and architecture specs. VTDigger sued last year for documents and discovered through a mediation process that 4 months of a former EB-5 Center director's emails are actually missing. And now we've come to a tipping point on the records issue as the courts have ruled in favor of requesters. Last fall, a case brought by the ACLU of Vermont spurred a new precedent when the Vermont Supreme Court ruled that public inspection of records should be allowed, effectively allowing requesters to view documents without paying fees. That precedent has led to a debate in the legislature about whether to enshrine new fees for inspection in the law. Tonight we will hear from Vermont Law School professor Peter Teachout, a constitutional law expert who will help us understand the history of the Vermont Public Records Act and recent Vermont Supreme Court rulings. Professor Teachout's remarks will be followed by a 45-minute panel with Secretary of State Jim Condos, Vermont Attorney General Chief of Staff Charity Clark, Governor Phil Scott's Press Secretary Rebecca Kelly, and ACLU of Vermont Coordinating Attorney Anthony Arapino, who has come in at the last minute. Thank you very much. Because Jay Diaz's family has the flu and he didn't want to spread T-ball. After the panel discussion, we will hear from Senator Jeanette White, Dee Wyndham, who is chair of the Senate Government Operations Committee, and Representative Sarah Copeland-Hanses, Dee Bradford, chair of House Government Operations, about where the legislation stands this session. Questions from the audience will be taken for 15 minutes at the end, time permitting. And now let me please introduce Peter Teachout, who is a graduate of Amherst College, holds a Juris Doctorate from Harvard Law School, and has been a visiting fellow for the National Endowment for the Humanities at the University of Chicago, and a fellow at Cambridge University in Dartmouth. We're very honored to have Peter Teachout, and without further ado, please welcome Peter.
Test this to see if we can get it going. Testing, no? Do you have one that works?
Plug it in.
Close. Has to be close.
Testing, 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 testing.
Can you give us a test?
One more time. Here we go.
Thank you. I was prepared to try to extend myself, but I appreciate having a mic because I sometimes have been accused of having a soft voice. So I'd like to welcome you all tonight to this panel discussion on why isn't the state an open book. It's a discussion of Vermont's Access to Public Records Act, what works, what doesn't work, and what needs changing. My own role in tonight's discussion is to cover 3 points fairly briefly. First, I would like to share with you very briefly a history of Vermont constitutional foundations of the open records law by discussing some of the provisions in the very first state constitution that provide antecedents for today's open records law. We'll see some of those provisions are a little bit blunt, a little bit crude, a little bit primitive, but at least it was an effort by the framers of the first Vermont Constitution to make government officials accountable to the people. Second of all, I'd like to provide a very brief introduction to Section 315 of Title I, which is the Access to Public Records Law, its basic structure and approach, and then finally discuss very briefly a couple of the more recent Vermont Supreme Court and lower court cases addressing the access to public records law. So let's start off with the very first state constitution. At the time of the Declaration of Independence, all of the colonies then, Vermont was not a colony, it was an independent operation. All of the colonies were told to rip up the colonial charters under which they'd been governed until then and to frame in their place state constitutions to provide for local governance. These were the first written constitutions in the Anglo-American tradition, and they all sort of reflect this experiment in trying to make representative democracy work on this new continent. One of the core provisions that you find in virtually every one of those first state constitutions, including the first Vermont Constitution, is the trustees and servants article. It was in Article 5 of Chapter 1 of the first Vermont Constitution, and I want you to listen to the language because it's really important. It reflects a fundamental commitment to making government officials accountable to the people and expresses why that is important. The language is all power being originally inherent in and consequently derived from the people. Therefore, all officers of government, whether legislative or executive, are their trustees and servants and at all times accountable to them. This was the fundamental belief of the framers of these new state constitutions and the Vermont Constitution, that if this new experiment in democratic self-government was going to work, it was crucial that the officers of government be held accountable to the people. But how did they try to do that in the first Vermont Constitution? Well, I want to share with you just a few examples of efforts to do that at this very early point in the Vermont historical experience. There was no existing state government at the time. There were no agencies. This was just the first document in our state's history. First of all, there was a requirement that the doors of the legislature be open to the public. This may not seem to you very revolutionary, but I will tell you, during the Revolutionary War, the dominant prevailing practice was parliamentary privacy. You will not find a record of deliberations in the colonial assemblies during the Revolutionary War, a single press account of deliberation, because the dominant prevailing practice was parliamentary privacy. Now you can understand why that might have been true during the Revolutionary period. They certainly didn't want English spies to know what was going on and what was being planned. But anyway, that was the tradition. So when you begin to move from that to the requirement that the doors of the legislature be open to the public at all time, that is a step in the right direction. The second requirement is kind of interesting, also constitutional requirement, that the votes and proceedings of the General Assembly be printed weekly. It was qualified only if at least a third of the members wanted it to be printed, but still, again, it was a step in the right direction. And it also allowed individual legislators to put into the record the reasons for their vote if, in fact, that was the weekly meetings and proceedings and votes were printed. Now, when I say the votes are printed, that doesn't mean just the cumulative votes. It meant it would say John Jones voted yea, Tom Smith voted nay. So it really was a way of holding the legislators accountable for the votes they cast in the legislature. Again, another important step toward governmental accountability. The somewhat odd provision requiring a cooling off period. Once the legislature had adopted an act, before it became effective, they had to print it, publish it, send it out to the people for comment before it returned to the legislature and was made effective. That provision didn't have a long life, but at least was another example of trying to make the legislature accountable to the people. One of the things that I found most interesting was another requirement. At that time, the executive branch consisted of the governor and council. There was a group of advisors called his council. So that was the executive branch. There was a constitutional provision that required that, here's the term, fair books be kept of the actions and proceedings of the governor and council, of members of the executive branch. Whether those books were open to the public for examination, unclear, but it was clear that the framers were very much concerned about good record management. I think maybe we ought to still be concerned about good record management today when we're talking about access to public. But that's an interesting thing, that fair books be kept of the actions and proceedings of the executive branch. Fifth, and to me, this is the fifth example, the most significant was the crucial role that the framers thought the press should play in holding government officials accountable. There were actually two provisions in the first Vermont Constitution protecting freedom of the press, and one was in the rights section, the Declaration of Rights section, pretty traditional. Freedom of speech, freedom of the press shall be protected. But there was a second provision in the frame of government section, giving the press a constitutional role in our governmental system. And listen to the language of that second provision. The printing presses shall be free to every person who undertakes to examine the proceedings of the legislature or any part of government. A constitutional provision saying this is a role of the press in our system. If we want to hold government officials accountable, press plays an absolutely crucial role in examining the proceedings of the legislature or any part of government. Now, I know these provisions seem like kind of primitive measures, blunt instruments. This is the very little baby steps toward ensuring governmental accountability. But you just have to go back to that point in time and say what they all reflect is this commitment to the idea underlying the trustees and servants core provision, which is that government officials are not our rulers, they are the trustees and servants of the people, and at all times must be held accountable to the public. So That's it. That's the framers' view, and those provisions provide the antecedents for today's Access to Public Records Act, for today's open meeting requirements. So now I'm going to fast forward to today. State government today infinitely more complex than it was back then. Multiple departments and agencies. So the work done by these original constitutional provisions in a very primitive form of state government now is done by statutory provisions. Statutory provisions that we're concerned with tonight, access to public records. Statutory provisions that ensure that meetings of government officials be generally open to the public. There's a separate provision in our statute dealing with access to court records. So we've got a whole set of statutory provisions out there that are quite complex in structure and nature, but they now are dealing with a much more complex governmental structure. Now, the relevant act is Section 315 of Title I, Access to Public Records. And if you read the preamble, it's really interesting. There are 4 basic provisions. 1, this act guarantees the public free and open access to governmental records. That's qualified later on, but that's the guarantee. 2, there is reaffirmation of the commitment to the constitutional requirement that government officials are trustees and servants, and at all times must be held accountable to the people. 3, it recognizes that opening up public records to public examination may cause inconvenience and embarrassment. There's a case that was decided in Rutland a few years ago involving disciplinary proceedings of the Rutland police for having watched porn on official computers during office hours, and the police did not want to have those records exposed to the public, but the trial court judge said, I'm sorry, but this may be embarrassing. I recognize it may be terribly embarrassing, but access to what happened in that police station is something the public has got a right to know about. That's part of holding the police accountable to the public. And the 4th provision, which is really important, it says these provisions requiring and guaranteeing free and open access to public records must be liberally construed. And I want to come back to that, or I hope you do later on in our discussion, because some of the question is, are agencies in fact running with the commands of Section 315, or are they resisting that notion that we ought to play a role in making sure the public has free and open access to public records? Now, very briefly, as Anne has told us earlier this evening, there are exceptions. So it's not as simple. Why isn't the state an open book? I suppose part of the answer is it ought not to be a completely open book. There are legitimate reasons for saying there are certain things that ought not to be disclosed to the public because important interests are involved. Medical records, our personal medical records, ought not to be made available for public examination. Our social security numbers, other private information. This stuff can be abused, but when disclosure of information and records would interfere with an ongoing criminal investigation, that is not something that would be in the public interest. Some cases revealing trade secrets, not in the public interest. There are legitimate reasons, whether you believe it or not, for claiming executive privilege to encourage free and open exchange of views within the executive branch. And in some cases, executive privilege is a legitimate basis for claiming a privilege. But as Anne has indicated, the problem is you read the next provision in the statute, there are more than 40 listed exemptions, and then you go, the legislature is required to list all the specific statutory provisions that carve out exemptions. I don't know, I got 261 bare minimum, and I think other people can count them differently. So it becomes a little bit, I don't know if you ever remember that story about the sleeping princess, where the prince has to go and kiss her to wake her up. But to get there, has to cut through this thicket of thorns. It's a little bit like that for litigants who have to navigate through these, 241 plus exceptions to Public Records Act. So on the one hand, you've got to be free and open access. On the other hand, but there are certain areas where really the public interest would not be served or would be impacted detrimentally by disclosure. I think perhaps the most important part of a Public Records Act is the procedures that are set up. They're supposed to work. Sometimes they work, sometimes they don't. What are the key elements of the procedure? First, strict time limits. You put in a request for documents, and the agency is supposed to respond within 3 days. Get a denial, you can appeal to the agency head, maybe another 5 days. This is for fairly simple requests, but anyway, strict time limits to respond. There's a burden if agency refuses to respond to a request. There's a burden on the agency to justify it. It's not the burden on the person requesting the information. The agency, as Anne has said, must make a list of all the documents that have been requested, a long list indicating those it's not going to provide and indicating the reason why. If the agency denies a request, it's supposed to not use a bludgeon or a sledgehammer in doing so. We aren't going to give you this entire document because there's a little bit of confidential information. They're supposed to use a scalpel and redact those portions that can't be disclosed. But anyway, all of these requirements are aimed at trying to make realistic the promise of access to government information that should be disclosed. When an agency action is challenged in court, one of the provisions in the statute is that gets priority treatment in the court's docket. Move right up to the front of the line. And then finally, there's a provision that when a plaintiff substantially prevails, not entirely, but substantially prevails, entitled to recover attorney's fees and litigation costs. So all those are aimed at trying to make it work. So I'm interested tonight in hearing, does it work or doesn't it work? Maybe it works in cases of simple requests for a limited number of documents, but doesn't work so well when you're talking about requests for hundreds, if not thousands, of records and documents. I'm going to leave for others to discuss tonight why, in other respects, Section 315 does not work always. But I think in part we can say some agencies try to respond in a way that's consistent with the spirit of 315, but other agencies have been known to resist complying. Maybe there are good reasons for doing so, maybe not. But I think that is an important question to ask. Are there some, for example, the Attorney General's office has developed something of a reputation for resisting compliance, indeed for fighting tooth and nail. I think I've heard that fighting tooth and nail against disclosing requested documents, and sometimes finally in court losing because that resistance was not warranted under law. Anne discussed a couple of the cases that have been decided. I think if I had to identify the two most important cases decided by the Supreme Court, one of them would be the Doyle versus City of Burlington case. That was a case because the law says agencies can require people asking for documents to pay for copies and to pay for the efforts involved in making the copies. But it doesn't say anything at all about whether plaintiffs seeking information can be required to pay for inspection. And oftentimes what people do is they take their cell phone in, show me the document, they do a click with their cell phone, that's it. And what the court held in the Doyle versus City of Burlington case is that, yes, agencies may require those seeking documents to pay for copies, but they may not require those seeking documents or records to pay for inspection. Okay? That's one that might be up for legislative consideration today. Another important case is the Tensing versus Attorney General case. So, William Sorrell, Attorney General, puts government documents on his personal computer. And the question was, does the Attorney General's office have any responsibility to seek out and discover and make available official government documents that are stored on Sorrell's personal computer? I think the AG's office resisted that one too, but the court ended up ruling, hey, look, if they're official government documents, they've got to be disclosed wherever they're located, on government computers or on personal computers. If I had to pick a third case, it really would be a lower court case, but I think it's going to have some important significance in the future. And that is, what about those situations where the government farms out government activity to private actors, privatize, like privatizing prison, right? We've got one going in Mississippi. Are those private actors subject to Vermont's access to public records law? Well, the lower courts have consistently held that you can't escape compliance with the state's access to public records law by farming out governmental activity to private actors. Those private actors too have to comply with the access to public records. So here we are at the end of my presentation, and I will say all of that has to do, and it brings us back to that core constitutional principle that all power derives from the people. That government officials are not our rulers, they are our trustees and servants, and we have to find ways in this modern complex world to hold them accountable at all times for their decisions and actions. So thank you very much.
Thank you very much, Peter. If our panel could come join us now at the center here, and then I'll introduce everyone. So I'll start with Secretary of State Jim Condos in the center, who has served as Vermont Secretary of State for the past 10 years. Prior to becoming Secretary of State, he served on the South Burlington City Council for 18 years and as Vermont State Senator from Chittenden County for 8 years. Anthony Irapino is a cooperating attorney with the ACLU of Vermont and a partner at Wilczek and Irapino. He was formerly at the Conservation Law Foundation and has extensive experience in public policy law. Rebecca Kelly is Director of Communications for Governor Phil Scott. She previously ran her own public relations consulting firm in the Boston area. She was also Executive Director for the Campaign for Personal Prescription Importation, which advocated for American access to prescription drugs from Canada. Charity Clark is the Chief of Staff to Attorney General T.J. Donovan. She has worked as an attorney in private practice in Vermont and New York City, and as a policy analyst to Governor Howard Dean. And Colin Mine, our managing editor, is open to co-moderate, and we'll get started. What a relief to have a microphone, I have to say. So, thank you all again for joining us tonight. And I'm going to ask the simple, dumb question that we posed as part of the headline for this forum, which is, why isn't the state an open book? And in your view, what does the public have a right to know? And this is for the whole panel. And maybe we could please start with Rebecca and then work our way over. Thank you.
Great, thank you. I'd like to steal Peter's answer. I found myself nodding along. I think he really outlined why there are public records laws and why the importance of transparency in holding government accountable and ensuring that we have government. That's a view that that Governor Scott takes, and that we've tried to implement across state government. I think what you also heard is we have a lot of work to do, and that there is a tension and there are challenges on this front. So I think that the answer is we try to be, we need to do better, and it's an important issue to keep focused on.
First, I just want to thank you again for inviting me here tonight. It's a privilege to be here talking about this very important issue. And when you said it looked like there were a lot of geeks in the room, I want to say guilty as charged, because it's nice to talk to people who care about this issue instead of my husband, or who's like, I don't want to talk about public records anymore, charity. So why isn't the state an open book? I think Rebecca's answer, I agree with Professor Tijot's answer, I agree with. We in our office, representing the state as we do, we frequently have to assert exceptions to the Public Records Act, and it can be, frustrating. Transparency is so very important to our government. We're very, very fortunate to be here in Vermont, where there is an expectation of transparency, and there's an expectation that there is a close proximity between the person and their elected official. And I feel so fortunate to be here and have that culture. But transparency isn't the only value that we have here. We also value the rule of law, we value privacy, and those exceptions appear in the Public Records Act. So I think that's the tension that we find.
We have our own down here. Thank you. I would say that, I guess I'll start off by just saying that all records that are created by government, all records created by government are public records. It doesn't matter what format, whether it's on a computer, on a disk, or on paper, they're all public records. Some of those records obviously have exemptions that they prevent disclosure. And I think that those are important concepts to recognize, but the first one is that all records created by government or acquired by government are public records. The second point that I would make is all the public records that we collect in government, they don't belong to government, they belong to the people. The people own those records, and they have a right to see those records. And I think Professor Tijot actually said it right. And if you look at both 315 and 310, which is the open meeting law section, both of the opening statements for both of those laws refer back to Article 1, Section 6 of the Constitution, which is the piece that he had read. So we are servants of the people, we are accountable to the people, and it is important that we recognize that as elected officials.
Yeah, just to go to the question about what does the public have a right to know? I mean, I think I want to emphasize something that Jim just added, not just records created by the government, but also records received by the government. So the people have a right to know what government officials are doing with their tax dollars and how the authority of government is being wielded. And on that acquired part, the records that are received by government, they also have a right to know who is influencing the decisions of the government and how is that influence being exerted. Now, why isn't the state an open book? I think there's two answers to that question. And when we talk about this issue, I want to make clear that we're not just talking about state government, we're also talking about municipal government. There's a lot of power in municipal government in Vermont, and there's a lot of, frankly, as the ACLU has seen and has exposed, there's a lot of opportunities for shenanigans. So we have, in some municipalities and in some state agencies, a deny first culture, where the immediate instinct is to deny first and to find a reason and a rationale in the law to support that denial, but that's the default position. That's not across state government as a whole, but it certainly is something that we see in different municipalities and different state agencies more pointedly than others. And the second is an issue that I know Jim has championed, which is we don't have consistent, efficient records management. A A lot of times people aren't trying to hide something. What they're really trying to do is avoid the work that it's going to take to actually give a correct response to a public records request. And so we really need to work on records management and consistency across municipalities and state agencies on that issue.
Thank you. Given that the Center for Public Integrity has given Vermont an F on open access to records, should the state overhaul the records exemptions and records law? And I'm going to hand this to Jim first, and then perhaps Charity, and we'll work out.
Simple answer, yes. Not so simple answer is it's hard to do. I think that it's incumbent upon us to actually review our exemptions, and as Professor Teachout said, there are some 40 exemptions that are listed in 317, which was, I like to call it the original exemptions that state law had put in place. But then there are another 200 or more that are scattered throughout the statutes. And in some cases, they contradict each other. We had a situation a few years back dealing with Abenaki recognition, and there was one provision in law that protected the information, and another provision in law that said that it was a public record. So we had to, the legislature actually had to deal with that at that time. This was probably about 10 years ago, I think, Senator White. But in any case, the fact of the matter is the legislature was so concerned about this that they actually asked Leg Council to actually start on a biannual basis every 2 years reviewing the statutes and determining if there were any new exemptions that had been put into law. Sometimes they're put in and people don't even know that they're there. But that's the problem that we run into. And I think that over time, those exemptions have really expanded. I know that the federal government over, I don't know how long it took them, but over many years actually reduced the number that they had down to 9, as Ann had stated earlier. And they made them broad enough to encompass the things that need to be covered, but not other things. And sometimes you don't have any one place to go for all of these except to go to the State Archives website or the Leg Council website, where all the ones that we know about are listed.
When we talk about making changes, you forgot, Jim, one of your favorites is the public records ombudsman. So I was going to get there. I want to give you credit, but I know that that's one of the criticisms when Vermont is criticized for not being transparent, not having like a central office or a central person, or as Secretary Kondos has referred to it, an ombudsman was one of the things we get criticized for. I think we also get criticized for not being having open access to people. One thing that our office does is when we receive a request for a public record, we publish that on our website. You can go to the Open Government tab on our website. We publish the request. We publish correspondence about the request, and we publish the response if there is a response. Sometimes we never hear from the person again, and it's a very anticlimactic journey when you read the back and forth. But we publish that, and I think that's something that has worked pretty well for our office, and it's been a way that we can try to be as transparent as possible. I am grateful that I see a lot of legislators in the audience, which is great. I think we have this opportunity. The Doyle decision perhaps gave us this opportunity to be having a more robust conversation about public records. It's such an incredibly important issue, and it's a credit to VTDigger to create this forum so we can have these conversations, and also to Senator White and Representative Copeland-Hanzis for having hearings where we can talk about these issues as well. I think changes are always a good thing. We can always do better, and appreciate the opportunity to have a conversation.
Sure. Well, this question is what we lawyers refer to as a leading question, because the answer is definitely yes. In terms of the need for an overhaul. And I see we've only got about a half hour left for panel discussion, so I'm not going to go through the ACLU's laundry list of things that need to be reformed, although a couple were just mentioned. The ACLU certainly supports the concept of an ombudsman, an intermediary that can make the process of appealing public records denials more user-friendly, less burdensome on the court system, and in fact on state and municipal governments. Sort of a non-judicial referee, an intermediate step. That's an important idea. Certainly taking a look at the exemptions and also the administrative costs. I think one of the things, I was an attorney on the Doyle case that has been mentioned, and it's a bit frustrating to the ACLU, I think, having looked at the legislative history that the court, of the statute that the court interpreted in the Doyle case, to think that we're going to have this discussion in the legislature again about whether the statute as it currently exists, as a majority of the Supreme Court has currently said that inspection of public records is free. We definitely need to overhaul the Public Records Act, but it would be a step in a very wrong direction to overturn the court's decision, which is a reflection of what the statute already embodies. So yes, we do need an overhaul, and there are plenty of good places to look in other states in New England and around the country, as well at the federal level. The one thing I would caution, though, is that just saying that there are fewer exemptions doesn't necessarily mean that they have a more open system. One thing that I worked on, Senator Condos, Laura Ziegler, Senator White, a lot of people, during the Douglas administration, there was an attempt to import one of the federal FOIA exemptions called the deliberative process privilege. Very geeky sounding thing, but basically what it means is everything that is not reflected in a final decision of state government is confidential. The process is concealed, and all you get to see is the result. That is a bad outcome. So when we go to look to overhaul, let's not make the mistake of thinking that fewer and simpler is necessarily the answer.
I would just add that I think there's always opportunity to look at how to improve government processes, especially one like this, where it sounds like you start here and over time things get added from all different angles and sides, and I think there's always a benefit to looking at that cohesively and determining where things conflict, where things are duplicative, and if there's an opportunity to streamline and make it simpler without weakening it, to your point, that's absolutely something I think that has value.
Charity, I was wondering if I could just re-ask the question. Does the Attorney General's office feel that the Public Records Act needs an overhaul, and if so, what might that look like?
Well, the Attorney General has certainly talked about need for clarity after the Doyle decision, so I know that would be one potential change. Other than that, I can't think of a specific thing. He definitely has supported the idea of an ombudsman, and I think that would be, in keeping with efforts to be more transparent and improve our score a little bit. That would be another one on the list.
Do you have any thoughts on whether the current exemptions, and this goes for both Charity and Rebecca, whether the current list of exemptions is sort of adequate? Can it be improved? Is it being interpreted too widely?
I think it's important. Now, I just want to give a caveat to the audience who doesn't know me. I am not a lawyer. I might be the only one not a lawyer up here. Okay, so I can't speak to every single exemption, but you're talking a lot about 261 exemptions. I think it'd be really valuable to look at how many of those are applied, how often they are applied, where is there duplicity that might be improved upon, are some conflicting, is it some where there needs to be clarity, and maybe we can bring that down, but also really looking at what's actually happening, how many of those are actually being applied, where might some be being over-applied, under-applied, and I think data could really help inform this, and that is something our Secretary of Administration is taking on and trying to better track across state government, what records requests we're getting, whether they're being fulfilled, why they're not being fulfilled, what exemptions are being applied, how long it's taking, I think that is an initiative that could really be beneficial to this conversation.
So I view the Public Records Act as having this, primary value of transparency and open government, and then the exceptions being the competing values, like, oh, except in this case, oh, except in that case. So I think looking at the exceptions and saying, okay, what's the value here? Is this value really worth it? And the ones that we use most commonly, I think, probably are. So it's, the attorney-client privilege, and the related attorney-client privilege. There's an ethics rule that you would violate if you violated the attorney-client privilege. So I think that one, and the work product doctrine, so that's very lawyerly. And then, as Professor Teachout mentioned, if there's a criminal investigation, not good to interfere with that. We use the personal, the right to privacy basically a lot because of our consumer assistance program, where just regular Vermonters are making a complaint relating to a consumer issue, and we redact personal information like, their medical situation, their age, things like that. But I think a good process would be to identify what's the competing value and to make sure, yeah, we really want to have this be an exception to this, the primary goal of transparency.
Can I jump in for a second, Colin? Because I think the ACLU would agree that in the wake of the Doyle decision, the statute could use some clarification, but I think we would sharply disagree with the Attorney General's office into how the law should be kept clarified. Because the issue from our perspective is that the cost of secrecy in Vermont is much greater than the cost of transparency. And it's not just the exemptions that are a problem for citizens and the media and others who are trying to hold government accountable. It is the cost. It is the cost of the process. It is the delay that is entailed in the process. And our view is that not only is the cost of inspection of public records free in law currently, but if you look at the legislative history, I think there's a strong argument to be made that the only cost that should be charged to citizens who request copies are for the staff time associated with making the copies and the paper. What happens instead, however, is that citizens, just be loud, that citizens are often charged the full cost, often of state attorney time, for looking at all those records and deciding how to redact those records and which ones to exempt. And that is a real problem. I don't think that was the intent of the legislature. I don't think it serves the constitutional values that inform the statute that Professor Teachout mentioned. And so if we're going to clarify at all, we need to clarify in the direction that the costs for all, from an equity standpoint, should be lower, and that the cost of transparency is lower than the cost of secrecy.
I do want to jump in here. I think that the law as currently written is clear. I don't think that it needs further clarification. I think that the Supreme Court has now made it even more clear. And I do think that there is some real problem going down the road of trying to find a way to add cost to citizens. Keep in mind, what we're talking about are the citizens' right to access of these public records. The citizens include everybody, including the lawyers who represent those citizens. It includes the media who acts as a watchdog for our citizens. It really is important that we maintain that ability for them to be able to access those records, to be able to hold our government accountable. I think that we get lost sometimes. It's it's the big law firms that are causing this problem. Yeah, that's a burden. We understand that. That is a burden, but it's a burden that falls on government. And I think if you go back, and Professor Teachout, you might remember the Crawford decision in 2011, which basically said, Judge Crawford said that it was a burden on state government with regards to those records being accessed by the public. I know that at the time, the Attorney General's office said that that was an appeal to the Supreme Court. Well, they had the opportunity, but they didn't appeal it to the Supreme Court, so that decision stands. But on top of that, we now have the Doyle decision, which I think gives greater weight to it.
attorney, but I believe that both the position that Anthony and Jim laid out there is also one that the administration has spelled out in its own legal memo to agencies, sort of reading the Doyle decision as requiring pre-inspections and even allowing the cell phone photographs of while inspecting records. Can you explain? I would believe that Vermont League of Cities and Towns is aligned with the Attorney General's office and sort of standing against that reading and having an alternate reading. So if you could sort of offer where you stand and why you don't agree.
So the Doyle decision, which is gripping, and I highly recommend giving it a read if you haven't already, envisioned that they say that the concept of copying and inspection do not intersect, and you're either in copy universe or in inspect universe. And if you are in inspect universe, it's free, and the legislature never intended for it not to be free, it's free. And if you're in copy universe, now this ability for the state or the municipality or whoever to receive reimbursement is triggered. And once you're in copy universe, the state, well, us, whoever, municipality can get reimbursement for their costs. For many people, there's very few costs or no costs. It's, slapping the piece of paper on the photocopier, and that's a nickel according to Jim's uniform fee schedule, and the time that maybe it's spent to make the copy. Of course, for our office, it looks really different. That's not the main chart and the main cost for our office. The main cost is redaction, because we're the lawyer for the state, so we have a lot of, we have to analyze everything, make sure any of the exceptions apply, like the privacy, which we commonly see, or the attorney-client privilege, things like that. And we don't want to just say, as Professor Teachout said, we don't want to just say, oh, this is attorney-client privilege. No, we want to read it, analyze it, make sure, use the scalpel, and it takes time. And so that's when we talk about reimbursement, that's what we're talking about. What the Supreme Court said is that, what is a copy? A copy is something that you can take and review whenever and wherever you want. And so what you're referring to, Colin, is our view, and apparently the Vermont League of Cities and Towns shares this view, is that once you enter copy universe, now the reimbursement provision has been triggered. So if you say, I'd like to inspect these documents, but you show up with your scanner or your cell phone and you say, no, actually I'm going to copy these documents, now you've triggered and you're in copy universe, because copy and inspect don't intersect. So that's what it says in the Doyle decision.
Can I just interrupt? Because I do think that there's an important distinction being missed, and that is that the statutes also say that it's actual cost to produce that copy. So if I reach into my pocket and pull out my cell phone and take a picture of a document that I asked to inspect, what is the cost to the state? Zero.
And we wouldn't charge zero. We would charge zero. We would only charge for the amount that the actual cost. We wouldn't charge for that. What the statute actually says is that the state can be reimbursed for the cost of complying with a request, which is why you can get reimbursed, not just for the photocopy, but the cost of complying with a request. So another example would be, I'm giving you the redaction example because we use it so frequently, but say a record is somewhere where it costs money to get it, you gotta go and pull the box and it's $2 there and $2 back, that would be another cost. That would be not just the photocopy.
I mean, I understand how you could read the argument as an attorney who's trying to make an argument and make the argument, but I don't think it's the right argument. And that's what's frustrating. And that, I think, is where the ACLU sees, not just at the Attorney General's office, but I'm not surprised that the Vermont League of Cities and Towns is aligned with that legal position. It is a cultural outlook. I mean, the Secretary of State is charged by the statute with interpreting, charged by the law with interpreting and upholding the Public Records Act. So is the Attorney General's office. Okay, so there are two differing opinions. That's where I think there's a need for clarification, because there shouldn't be that wiggle room. What should be clear is that there's no two universes. What we're talking about in recovering costs is actually the cost that it takes to make the copy, the machinery, somebody standing at the copy machine, but all the rest that goes up to getting you the documents to inspect or to take away, that shouldn't be something that's charged. There's a real equity problem with that too. The Constitution doesn't distinguish between Vermonters' financial means, okay? The government should be open to all regardless of their ability to pay, and the kind of interpretations that we're debating here really raise the bar and make it hard for nonprofit news agencies as well as citizen activists who may not be of means to get access to records. And there's just no compelling evidence that I've seen that the cost of transparency in Vermont is too high for municipalities to bear, too high for state government to bear. We hear about these, extreme cases or horror stories, yet the legislature has time and again ordered studies to see how real these worst case scenarios, sky is falling scenarios are with respect to voluminous public records requests, and they just haven't materialized in a way that justifies the kind of interpretation and deny first culture that leads us to a place where we're imposing these onerous fees on the media and on citizens of Vermont.
On that note, what is the real cost to Vermonters when government isn't transparent? How do real people suffer? Anthony?
Well, I mean, the ACLU has done a lot of cases, including with police officers, use of force by police officers, information about implicit bias in policing. You have to remember the government wields tremendous power. And the tremendous power that the government wields, one of the checks that we have on it is transparency. So in terms of allowing government practices that are abusive, that are inconsistent with law to go on in a certain police department or a certain government agency for years and years and years, that has a cost. I know that we have VNRC is a sponsor here tonight, and VNRC and Conservation Law Foundation and other environmental groups have tried very hard to use the Public Records Act as a tool to figure out why we are not getting consistent enforcement of our water quality laws. And we're paying millions and millions of dollars in public money to clean up Lake Champlain, to clean up our local waterways. And yet, we've passed law after law, and we don't have consistent enforcement. And when you have groups that are trying to bring to light what is happening inside these agencies that is not resulting in effective enforcement of our clean water laws, and that's affecting everyone. Dirty water, polluted water is affecting everyone, whether they're paying for it, or they're losing their aquatic resources. That's an example. The EB5 scandal that the VTDigger has used the Public Records Act, or has tried to use the Public Records Act to bring to light, is another tremendous example. I mean, we're still calculating the damage that's been caused because we did not have greater transparency around that program, and the work that Digger and other news outlets have done to bring that to light have stopped those abuses. But boy, wouldn't it have been better if in the first place it was easier to bring that to light, and that could have come to light sooner, and we could have had those reforms to control those costs.
I think that one of the things, we can talk about the large scale abuses, if you want to speak about it, but I think what I like to look at is, what does the average Vermonter face? Does the average Vermonter who goes to get a series of documents that they want to look at, and they're told, well, you have to pay me $120 to do that, how many times has that happened where the Vermonter just walks away dejected? That's why I've been pushing the idea of an ombudsperson that would actually look at this, that would be that middle person, that could assist also state agencies who request an opinion from the ombudsperson as to whether this meets the test of the law or not. And I think that is a real possibility that would really help Vermont in the long run. Many of the states around us, New York is one of the most famous for having an ombudsperson, but many of the states around us and across the country have ombudsperson people that are in place to actually act as that middle road between their denial at the agency level and going to court. Because the last thing a Vermonter, most Vermonters will do is go to court. It's intimidating to them. So they're not apt to do that. So I like to look at it from that standpoint, and again, I can't say enough that the public has a right to know. That is their right. The Constitution says it's their right. They have a right to know what their government is doing and to be able to hold that government accountable.
I would say that the thing that comes to mind with that question is just trust in government and the integrity of government. It's so important. I can't emphasize enough. I feel in Vermont we're so fortunate to have this expectation of our government that they will be transparent and there is accessibility in a way that other states do not enjoy. I think the real cost for me when I think about this would be just the sense of trust that people have in their government and the integrity that the government has.
I would just reiterate what I said earlier in that these laws are in place for a reason. There needs to be a level of transparency for government, and that brings more good government. The level of accountability by having open records is important to ensuring not only that the public knows what government is doing, but also that government knows the public and know what government is doing. And I think that yields a level of critical accountability.
We have a number of questions yet to get to. So one issue that we often face is sort of, we claim things are in the public interest and request records, and the state says that it has, the state or the Attorney General's office says that it has responsibility to protect state officials, something that Professor Teachout mentioned about sort of things that are embarrassing, personal information. And I'm wondering if you can talk a bit about when the state finds itself both compelled to act in the public interest and legally bound to defend or represent state officials, then how do you sort of balance that loyalty and where does the state's loyalty lie?
I'll leave the how do you defend state officials, because that falls to the Attorney General's office as far as being a state's lawyer. But as far as protecting public officials, there's no exemption for protecting public officials. So if there are exemptions as far as confidentiality issues or personnel records where the law would apply specifically, that's abiding by those laws versus protecting the official. So I think the state has an interest in ensuring people are held accountable, but also complying with the law. So I think we shouldn't be finding ourselves, there shouldn't be an interest in protecting an official versus making something public or holding somebody accountable. That's not where the interest should be, and that's not what the exemption applies to.
For us, because we're the lawyer for the state, we have an ethical obligation. We have a duty of loyalty in the ethical in the rules. So our duty is to our client. We're kind of a unique probably person here. So that's an easy question for us because we're required as lawyers to have that duty of loyalty. So I think I'll just pass the microphone to the secretary. Oh, sure.
So you talk about how that's sort of automatic for the Attorney General's office that you're going to act in your role as the sort of state's lawyers, but TJ Donovan in particular is an elected representative of the people. So I guess I'm wondering, is it that cut and dry that in all cases the Attorney General's office will represent the state official over the sort of public interest?
I think not knowing specifically what factual situation you're imagining with your question, there is literally an ethical duty that we have, just like the ethical duty I mentioned before about attorney-client privilege. We are required to take a whole class on it in law school, all the ethical rules, and one of them is a duty to your client. So we have a different, perhaps, relationship with public records than others in state government because we have that automatic duty that we're required to follow as attorneys. And just like all of us, if we need an attorney, those apply to us. We get the benefit. The state gets the benefit of having an attorney and all of that entails, so the relationship and the duties and the attorney-client privilege and all of that.
My only question is who serves the public? And I think that's a concern. That's why, again, I come back to the ombudsperson, although it doesn't have any, we don't have one, and it doesn't necessarily, it depends on what the legislature, how they would set it up with its authority, but at least they would be able to administer the public records law from that standpoint. In the Doyle case, I actually went out and had someone actually write the amicus that we filed on behalf of supporting the ACLU because I didn't feel that that I was going to get the support I needed from the state. There was mixed emotions coming from mixed messages coming from the state as to whether they supported the case or not. And so we went out, my office did, and we worked with a private attorney. But I don't think the public has that ability necessarily to go out and hire an attorney to do that. So where do we leave the public? How does that, how does the public deal with issues like that?
Yeah, when we talk about lawyers' ethics, there certainly is a duty of loyalty owed to the client, but there's also another ethical provision which says lawyers can't have conflicts of interest. And I think what Colin has pointed out, and Secretary Condos as well, is if the Attorney General's office has a duty to defend state employees, certainly that's true, and we want to make sure the state taxpayers, if state employees are wrongly accused, that they get the best defense that they can get. But it seems to me that it's a problem if you have the same office being asked for public records that are in the public interest to have out there and disclosed about the potential malfeasance of state employees, and they are also the office that's the gatekeeper of what information is released pursuant to the Public Records Act, that is a conflict of interest, and that's the way the Attorney General's office feels about the discharge of its duties under statute and the Public Records Act, two different parts of the state law, then something like what Jim is talking about from the ombudsman, somebody who could stand independently and assess the situation as the Public Records Act requires, without that conflicting duty of loyalty to the state employee who's accused of wrongdoing. That's the direction we need to head, because the conflict of interest in the Attorney General's office, when it comes to a conflict between the public right to know and the defense that's owed to a state employee, that's a hard conflict to resolve. I don't envy them that task. We've got to fix that problem if that's the way they see it.
If I could just ask you, Rebecca, to follow up on that. I mean, obviously, many people working in the state agencies that your office oversees, would be involved in these types of cases. And I guess where does the administration sort of fall on where the Attorney General's, to toss out a current case we have against Ed Adams, who is a former superintendent of Springfield Prison. Originally, all records of his discipline, he was demoted for allegations. We're not really sure what they are. We're trying to find out. Initially, that was completely found to be exempt as personnel records. That position has changed somewhat since the issue of prison oversight has become more sort of central. But do you think that state employees sort of have a right to be represented by the AG against disclosure, that sort of thing?
I think the Adams case is a really good case to illustrate sort of the challenges that can come up and the tension that can exist in these laws as well as other laws. So, for example, the original decision to disclose, that was where you look at the exemptions and you weigh them, and the exemption applied. Over time, there became a public interest based on a lot of new information that was relevant to that situation, that it tipped where Secretary Smith made the decision that it's now tipped where the public interest outweighs the reasoning for that exemption. So he moved to release those records, and now we're being sued by the SCA and the individual to disclose them. So this is a scenario where we're being sued for not disclosing and being sued for trying to disclose. So it really illustrates the tension, I think. But it's also caused us to take a look at the human resources process to make changes so that there is more transparency. It's something that Secretary Young is looking into. It's something that Secretary Smith has been involved in because of this specific case. But HR is taking a review now to look at are there scenarios where the public interest outweighs that personal privacy concern.
Just thoughts on that question, whether the public interest sometimes supersedes the the importance of the personnel exemption.
You know, again, I would come back to our values, and, you know, I think we have a value in Vermont of, yeah, your personnel records are private and that sort of sense of privacy that we have, and so I think it's a matter of weighing out the values again of transparency in government. You know, what's more important, the transparency of government, the accessibility of records and information, or this person's or any of our, you know, personnel records and the privacy that we have. I think that's the challenge.
I don't think the question is so much about personal privacy, it's about whether or not we should know decisions that are made in state government. So like, at Adams, like, we're not asking for information on his medical information or his education records. We're asking for, we want to understand why he was demoted as the superintendent of the state's largest prison, which I think is different than sort of protecting personal privacy.
I mean, it's a personnel record, so I think that's where the personal privacy, it's your personnel record, so I think I guess you and I just disagree.
Doesn't the public have a right to know if somebody has been involved in this crime?
Again, you're weighing out the values. Yeah, does the public have, you know, right to know this, or does this person have a right to privacy? And these are the challenge that, you know, are right there in the Public Records Act, and I'm sure that Senator White and Representative Copeland Hans's committees are probably, you know, working through this session is weighing out those different competing interests.
And I just want to add that my office also oversees the Office of Professional Regulation. So we have some 75,000 licensed professionals that we regulate. When there's a complaint received, that complaint is kept private. Nothing becomes public until there is a charge that has been filed, and then the disciplinary aspect is published and it is posted on our website. So I think that it just really comes down to what are we looking for, but in the case of professionals, whether it's a nurse, an engineer, a tattooist, a barber, cosmetologist, whatever, you know, if they're charged with something and they are then there's a disciplinary action taken, that is posted on our website for the public. And I know that there are a lot of other professions that are in other agencies that are not, and so the government, the public does not know what is going on.
We've got 45 seconds to count. Okay. Should there be a penalty for violating the Public Records Act? How should the Public Records Act be enforced? There are no penalties unless you've been caught destroying them, and that's a hard thing to prove.
Each person has 5 seconds.
Well, if you have the wherewithal to file a lawsuit and you win, you get attorney's fees. That wasn't always the case. That's a recent reform. It's an important reform, and there are other things, but I will pass on.
That actually passed, I think, in 2012, and it used to say that the courts may award attorney's fees, and in the previous 30 or 40 years, there had only been like a handful of cases where the courts actually awarded attorney's fees. So the legislature, in its wisdom, and we supported it, was to change one word, may, to shall, so that if you substantially win, you will be awarded your attorney's fees. That is a pretty strict penalty that can be applied. As to there's always, I believe, in statute, I don't know the actual statute number, but if someone is willfully withholding information when they shouldn't be, they could be charged individually.
Criminally?
I don't know about criminally.
I'm sorry to say I haven't had a conversation with the Attorney General about this, although my fellow panelists haven't directly answered the question about a penalty versus the attorney-client fees, the attorney fees. I'm sorry, I don't want to waste time weighing in. I haven't really thought about this issue much, but I think it's one to consider in the legislature looking to make changes to the statute.
I think Secretary Condos touched on this a little bit, but I think there are some levers that can be pulled to hold people accountable if they're found to have willfully and wrongfully violated this. But I don't know the specifics on that.
That could be made more clear.
Well, I think that's, thank you all. That's it for the panel. Thank you all so much for participating. Don't leave. Thank you all. If you want to take a seat up front here, there may be questions coming your way in a minute.
Liz is
And then Senator Jeanette White, if you'd like to come up, please. Senator White is the chair of the Senate Committee on Government Operations, and her committee has been looking at this issue, and so she'll say a few words about where we are right now. Oh, and Sarah's here too. Sarah.
Hi, I'm gonna join you. Good. Oh. No, I'm gonna stand up because I can't, otherwise I can't see the floor. So, it is true that every record that's produced is a public record, but, and we always hear the buts. Open meeting law and public records law are always changing sometimes because new things happen, sometimes because of new technology. So it's an issue that every year, almost, we deal with this issue. The Doyle decision certainly made it evident that we needed to do something this year, at least listen to what was going on. I do think that in my opinion, there was some misunderstanding about when we charge and when we don't charge. Because if you look at the chart that the Secretary of State's office has about who can be charged and at what rate, we're not going to be paying attorney rates for standing at a copy machine, and yet there is a rate in that chart for attorney's fees, of how we charge for attorney's fees. So I think the assumption always was, by the legislature, that maybe not everybody, but I think the assumption was that could be a charge for preparing and redacting records, because otherwise we wouldn't have a chart that talks about attorney's fees. I don't know how many attorneys actually stand at the copy machine and make the copies. So we do have that chart. So this year we are addressing a number of issues in our committee. So the issue of paying for staff time to prepare and redact. Should we or shouldn't we? And should some agencies do it if you want a copy, and some agencies don't do it at all. So we're looking at that. We're looking at how far it extends. Professor Teachout talked about nonprofits. So the way the bill that we currently have reads is that anybody who gets a contract with the state or a grant would be subject to public records. That extends to probably every single organization and nonprofit, and probably some private enterprises also, if they are getting contracts for construction or anything. So we need to look at that. We're looking at that. And good records management is one of the things that we're really focusing on, because a lot of this is bad records management. And so we need to have a bigger stick to make agencies more responsible for having better records management. And And we have, Tanya Marshall has given us a copy of an audit that's done on all the agencies, so we can see which agencies are complying better and which ones aren't. And in terms of an ombudsman, we haven't really talked about that, but what we heard from Tanya was that the agencies who are working with her and have a person in their office that's working directly with her around records management are being able to comply much better and much faster. So we think that that's a really good step. I just want to comment a little bit on the exemptions. In 2012, there was a committee that reviewed every single one of the 263 exemptions. And we made decisions about which ones should remain and which ones should be eliminated. And the idea of having just a few exemptions, then you have more of a balancing act with each of those exemptions. So we chose to go with some very, very specific exemptions around, and some of them are really arcane, I guess is the word. I mean, they apply only to one situation. But we felt it was better to have very specific exemptions than have just a few broad ones. And we had our legislative council do a review, and he found that he looked at every single public records request over a year and logged them in, who made the request, not what it was for, but, and because we can't ask that, but who made the request, whether there was an exemption claim, and if so, which exemption was claimed, and how long it took to produce the records for the person. And they found out about 95% of them were complied with within the time frame. So most public records requests are complied with immediately, and there are big ones that aren't, and there are ones that are take more weight than others. So those are kind of the issues that we're dealing with this year. We have not come to any conclusions. I'd like to stand here and say we have a really elegant solution. And as Brian Collmore, who's on our committee from Rutland, said, every time I think I come up with a really elegant solution, I find out the next day it wasn't so elegant after all. So we keep struggling with it.
So I'm going to go really quickly because I know that there are probably burning questions that you would like to ask that you don't need to hear from me on. So I'm the chair of the House Government Operations Committee. Half of my committee is very new to the government operations world, including many of them being first-term members. So we have taken some background testimony. We wanted to understand what the Doyle decision was about. We wanted to hear from the Secretary of State's perspective and the Attorney General's perspective. And so we've done a lot of that background testimony, and we are, I think, ready to dive into whatever it is that you find for an elegant solution. If you're sending something over to us, we will be ready to act on it. But there's a very strong sense of my committee that we believe that citizens have a right to have access to information about what their government is doing, and that it is our duty to spend as much time as we need to make sure that we get this question done right.
Thank you very much. Thank you. So if anyone has questions, please, we're going to hand you the mic, and so you'll have to come to the front. And the panel could come back up, and maybe Peter and Senator White wants to sit here, but Sarah, if you want to come up, if there are any questions.
Please come take your mic so you can.
I don't need a mic, do I? I have a question for the panel, mostly for Chief of Staff Clark. And then I want to throw a monkey wrench in for burning bush into the fire. Frank Davis, and I've come down from Derby, Orleans County, where the EB5 scandal is pretty hot up there. Now, the question is kind of a, pose it this way. Suppose that VTDigger, with all of its resources and money, has asked for records from the Attorney General and has paid the fees for redaction and review and 2,000 pages, no copies. They just, well, no copies. Copies or no copies. That's not material here. But they paid for that, so it's been inspected and redacted, and now I come along the next day and I say, I would also like what they got, 2,000 pages. And I'll click my phone, I'll take the pictures myself. Now, they had to pay lawyers' fees or whatever, but does that mean I only have to pay $2 to pull a box that's already been done? There's a fairness issue there, and that's not fair, because the first one in line would have to pay all those fees, and everybody else in line practically nothing. The second question is something that I think Professor Teachout touched on, and so it has occurred to me, and actually I came here with that intent also. In September, a judicial administrative order went into effect, and that has to do with the press in the courtroom and who can make voice recordings, who can take pictures, who can make video recordings of the proceedings in a courtroom. And it is only the registered press. What the heck does that mean? Can I be the registered press? And can I be prohibited if I'm not registered? And I'm a school teacher, and I want to come in and do some recordings for my classes. I'm prohibited, but the guy next to me has been registered as a press person. He can do it. We're both sitting there with our phones, just holding it out. We're not interrupting anything. And I think this is also prohibiting me from a public record, making my own public record. So those are my questions. Thank you.
First of all, thanks so much for making the trip.
Is this on now?
Yeah. Thanks for making the trip.
Well, that was in daylight and going back in the dark.
Thank you. Yeah, thank you for leaving to the dark. That's brave in a snowstorm. I can answer your first question. I can't answer your second question. So it's worse than you depicted. It's not $2. It's actually free, because once someone pays, we put it on our website, so everyone gets the benefit, and that other person paid for it. So it's not a perfect system. You're right, but that's how we do it. And for other offices, someone will pay for it, and then they don't upload it to the website, so no one gets it. Everyone kind of does it differently. For us, yes, once someone pays for it, we've done the work, and we let everyone benefit from it. But yeah,
That ain't fair.
Well, and that's why the ACLU believes that there should be, the only charges that there should be is for the actual cost of making a duplicate record. The redaction, the attorney time, that's the cost of doing business. That's the cost of running a transparent government that is accountable to the people. As our Constitution said, we shouldn't be charging people to bear that cost. That should be baked into the budget of every state agency. Okay, that's just the reality. Our solution that doesn't have a division of attorney time for redaction and reviewing records, it's simple, it's pro-transparency, and it's equitable, and that's the way the law should be in the state of Vermont. I hope that the legislature moves in that direction.
Almost got you. My name's Rick Hubbard. I live in South Burlington. And Charity, another one for you, but with others to comment. If we citizens elect representatives and we have a state government that is to look after our interests, and that's an essential part of it. And we get into a situation where, on public records, the Attorney General's office is beholden to its client under the Code of Responsibility professionally for attorneys. And the client looks after the state's interest, and those interests are perhaps in conflict with our citizen interest. Is the Code of Ethics really prohibiting by its forcing you to represent the best interests of your client? Are you really at odds with delivering justice to the citizens of Vermont? And I want to be specific. If we look at the EB-5 case, we have a situation where, as a citizen, and I'm sure I'm not alone, there is plenty to suggest in what is public that there have been omissions in oversight to some, maybe a huge extent, and individuals and perhaps some parts of the government institution, from the Attorney General's point of view, on behalf of your client, the state, might like to be protected from having that disclosed. But if you are our elected representative attorney looking after the state's interest, where is the interest with equivalent resources looking after our citizen interests? Now, with respect to the Public Service Department, we've answered that, because we've divided the functions into two parts. One part makes decisions on the actual rate structure from the various applicants, but then there's another part that is paid with attorneys, with background, with resources to look after the public interest. Where is the equivalent to the Attorney General's office in this case looking after the public interest? Now, it's one thing to say that individuals can stand up and bring a legal action, or Ann in Vermont Digger, but it's a huge imbalance of power. That isn't right. And nothing that we've talked about tonight has answered settling that imbalance of power. I submit, perhaps, we're looking a little too shallowly, and we should be looking way beyond an ombudsman. This other group, looking after citizen interests, might get involved in in the way we handle our ethics complaints. Citizens have a different interest than perhaps legislators. Look at how the Federal Election Commission works in Washington. So I pose it partly to you, Charity, but also to everybody else about thinking a little more broadly about whether our system is actually delivering justice.
Well, thank you so much for making the trip and for that really interesting comment. The EB-5 case for us is ongoing. The state's still in litigation, so the records, we're waiting for that case to be over to release the records that have been requested. But to your broader point, it's a challenge for the Attorney General's office. We wear a lot of hats, and sometimes we have to make very unpopular decisions. You don't get to be prom queen if you're Attorney General, and it can be challenging to represent the state, our client, and have all these other interests. When you were speaking, I was reminded of our consumer assistance program, which does help consumers with their complaints in consumer context. And we actually, that's housed at UVM, so that we can have a more moderate, we letter mediate at the consumer assistance program. And it's not in state government. The people who work there largely are UVM employees, not state employees. It's kind of a unique situation that's not quite in our office. So anyway, when you were speaking, I was thinking of that, but really interesting perspective. Thank you.
I'd just like to bring it back, and I think Charity brought it up, and I neglected to, but records management is really one of the major keys to all of this. Right after the Doyle decision, and after I had published an op-ed in support of the Doyle decision, I received an email from a superintendent of schools who said that they had a records request that was going to cost them $40,000 to comply with, and they wanted me to know that I was wrong, and that they were advising their school districts, their individual schools, to put $100,000 into their line items for their school districts in order to comply with records requests. Part of my answer to this person was to say, well, if you had better records management in the first place, you wouldn't have had that tremendous cost, and you'd be better served to use the $100,000 to develop a better records management system. They're out there. And I think state government has not been, to put it bluntly, has not been real supportive of the idea of records management. We speak about it, but it's not. I know the state archives falls under my office, and their team works with many state agencies to try to provide input and advice on how to better manage their records, and it doesn't always work. But we're working at it. We continue to work at it. We work with most of the state agencies, and it's something that is near and dear to our heart, in that if we had better records management in the first place, complying with it would not be as difficult. And that's dealing with the records when they're created or acquired, rather than waiting until someone asks for them to actually work at getting them ready. It doesn't take a lot of, it's not rocket science, and we have a very professional team at the state archives that works on this, and they try to help any state agency that wants it. Not all state agencies embrace it.
I mean, every elected official, regardless of their function in state government, swears an oath to defend the Vermont Constitution. And as we've heard from Professor Teachout, the values of open government are enshrined in the Constitution and as well in our Public Records Act. And so part of the challenge and the answer to your question is there are judgment calls to be made, and it's up to ultimately up to the voters to decide how the judgment is being exercised and whether there is a different balance that could be struck in terms of, upholding the law in terms of its exemptions, but interpreting and construing the exemptions liberally as the legislature has instructed in favor of the values of open government. So it's not as cut and dried to differ with Charity. It's not as cut and dried, I think, as the Attorney General's office always makes it out to be. There are judgment calls to be made, and there is specific instruction from the legislature that the exemptions in the act should be construed narrowly in favor of transparency. And so the ACLU is always going to be in favor of those liberal constructions in favor of transparency.
To the gentleman's question, I would add one other important piece is that records aren't the only way to hold government accountable. And in the case, going back to the Adams case that Colin had asked about earlier, for example, not on that specific case, but generally on personnel records, they may not be disclosed for a FOIA request, but if there is a crime or evidence of a crime, that is turned over to state police. They then conduct an investigation. They then turn their findings over to the state's attorney, or if it was elevated to a federal level, they would turn it over to the U.S. attorney, like in the case of EB-5, and that entity then either pursues criminal charges or determines there's not enough to pursue criminal charges. So there are remedies that go well beyond public records that are in place. Public records are an important piece of accountability and making sure people have faith that, because those later steps may yield not the result you would have expected. So public records are a part of having faith that that process was executed. But there are other remedies in place to ensure accountability and oversight of these issues.
We're going to take one more question.
your office, or Attorney General's Donovan's communications with Planned Parenthood through the age 57 legislation, which whatever one feels about abortion, this is about conflict of interest. And as a lawyer, Anthony knows you either get the shotgun approach to discovery or you get nothing. And the Attorney General's office told me that there are over 3,000 emails, and I'm being told it would be $7,232 for us to see them. In the governor's case, there's been an invocation of executive privilege and attorney-client privilege. So it really hits on this core issue, and I'm an attorney, of the ethics code and of that conflict. And I want to know if Jim Congress would be my ombudsman to resolve both. Do I need to sue both of you, which I can do, and see if I can get my attorney's fees? Or I'm wondering, because I'm building on the last question, what would you propose, Anthony, as the solution? Would the ombudsman be the correct answer? I mean, maybe private citizens on a panel? Because what's happened in this case, many federal cases have suggested we should err on the side of transparency. In both cases, we have no transparency. So unless I can raise another $5,000, I'm never going to know in either case whether there were inappropriate associations. So Anthony, you've interested me. I'm a big ACLU guy. So do you have a proposal that would maybe help us avoid this problem, this conflict between, for lawyers, this conflict of interest issue?
Well, I don't have a specific proposal, but I would say the ACLU has in the past, in the Doyle case, but in many other cases, resorted to the third branch of government. I mean, there is already in our constitutional system a referee for these kind of disputes, and that is the courts. It's not easy for everyone. It's not cost effective for everyone, but the chance of attorney fee recovery is what often interests private attorneys. I am a private attorney who has done public records cases as well. So, you know, there are times when, you know, it is important to go to that third branch of government.
So I hire you.
I'm not saying I'm taking your case, but I am saying that there are attorneys to do that work, and sometimes that is, unfortunately, sometimes that's the best answer that our system of justice and our system of government has to offer. I think what's attractive to the ACLU and others about the ombudsman is that there is less cost and less formality potentially to an ombudsman process and office within state government that could help referee these disputes without the costs and the conflict that comes along with litigation.
Well, I want to thank everyone for coming, and it's a great pleasure to see you all. I'm so glad so many people are interested in public records. Thank you again to the Vermont Bar Association, to the Vermont Natural Resources Council, and the ACLU of Vermont for sponsoring this event. And thank you, audience, for coming out tonight. We look forward to seeing you at our next event, Tuesday, March 24th. Should Vermont ban vaping at the Burlington High School? Thank you again, and good night.
Hey, Ellie. You heading out to Burlington? I'll bend you 50.
Yeah, definitely.
It would be, because it's going to take me like a minute to pick up my stuff is the main reason. I feel like really bad making it. I thought I had it around.
No, that's really good. Good morning,